Welcome to Unit 3. The topic of Unit 3 is this: the liability that you as a server can be accountable for. Information to be covered in this unit is number 1, what a third-party liability lawsuit is. Number 2, the potential legal consequences of overservice. Number 3, what you can be sued for. Number 4, civil lawsuits for serving a minor. Number 5, who can sue you. Number 6, damages you would have to pay. Number 7, using a logbook. And number 8, how to protect yourself from a third-party liability lawsuit. It is important for you to understand that there's more to serving alcohol than most realize. This unit will help you in your serving decision and your acts of intervention. The definition of intervention is this: intervention, the alcohol server's legal and professional responsibility to control and limit the customer's consumption of alcohol to prevent drinking to intoxication or visibly intoxicated persons from continuing to consume alcohol, or minors from drinking alcohol, or intoxicated persons from driving. Third-party alcohol liability lawsuits. There are 3 parties involved in a third-party alcohol liability lawsuit. The first party is you and your establishment, the server and the licensee. The second party is the intoxicated person, the drinking party. And the third party is the victim, the person outside of the alcohol transaction. Here's the way it breaks down. Mrs. Jones comes into your bar. She sits down and she's serving her some Merlots. And after a while, she said some Merlots. She can't quite get the word out of her mouth. It comes out something like, "Lots of Merlot, please." Like, "Hey, drunk lady, you're done. Dang done." She's like, "Excuse me, I'll tell you when I'm done drinking. I'm going someplace else to appreciate my business." And she gets up and leaves, and you do nothing to stop her. Now, you might make a comment to her, like, "Are you okay to drive?" And Mrs. Jones says to you, "Yep, I'm fine," and she heads out the door. Well, she's driving around the road, and here comes Mr. Smith, and she crashes into Mr. Smith's car and hurts him really bad. Here's what can and probably will happen. Mr. Smith will sue Mrs. Jones for hitting her. Then Mr. Smith can sue you and your establishment where you're serving alcohol for over-serving Mrs. Jones. These are not new alcohol liability laws. They go way back into England. They're part of the common law. Here's a quick trip to law school for you. A tortfeasor is a civil wrong. Negligence is an example of a tort. Under Oregon law, you can be negligent if your conduct unreasonably creates a foreseeable risk to a protected interest. In terms of liquor liability, Oregon courts recognize that it is foreseeable for someone who is visibly intoxicated to cause injuries to himself or others. If your actions caused or contributed to his being visibly intoxicated, then you can be held liable. If you are found liable, you will be responsible for the claimant's damages. Those can include the tangible losses such as medical costs, property loss, etc., as well as the intangibles such as pain and suffering. A tort is a civil wrong. The category that you as a server can fall under is negligence. This tort will require 4 elements for it to be completed. 1 is a duty to another. This is created by common law. Common law is decided as the common to the area of where you reside that if you serve alcohol to someone to the point of visible or apparent intoxication, you should get this person to safety. Yeah, you call them a cab, you call their friend, their spouse, or they just sit there until they get sober. Remember, if somebody's intoxicated in your establishment, not causing a problem, purchasing, possessing, or consuming alcohol, they're welcome to stay. Number 2, was there a breach of this duty? Did the server of the alcohol do nothing to stop that person from driving or walking away? Number 3, probable cause. Is it foreseeable that this individual who is now intoxicated, that if they drove or walked away that something bad could happen? Obviously, yes. And number 4, you have your actual damage, your tangible damages, such as property damage, lost time from work, medical costs, etc., as well as the intangibles, i.e. pain and suffering. A third-party liability lawsuit is this: if you overserve somebody alcohol and they injure somebody else or cause property damage, there's a good chance you can and will be held accountable in a court of law. All of those involved in the alcohol transaction can be named in the lawsuit. The manager, the host, the hostess, the valet, the attendant, the bouncer, etc. will all be named in the lawsuit. You can be found liable if 50% of the jury find your actions resulted in the claimant's injuries. All that is required to find you liable is if a jury determines it is more probable than not that your actions resulted in the claimant's injuries. A law journal reports that 80% of these lawsuits will be settled out of court for $100,000 or more. The cases have multiplied by 300% in recent years. The statute of limitations for negligent actions is 2 years in Oregon. If you are sued under the Oregon liability statute for overservice, you must receive notice of the suit within 1 year of the actions that are claimed to have resulted in injury. If a person dies, notice of a dram shop action or a third-party liability lawsuit, an action under the liability statute must be given 1 year after the date of death. A third-party lawsuit is a lawsuit in which the injured person, who you did not serve, sues you for injuries he claims to have received because you overserved the defendant. If you overserve someone alcohol, you can be held directly accountable to the injured person in a third-party lawsuit, so don't overserve. Problem is, it will happen. There are a lot of different variables which can make it difficult for you, a server involved in the service of alcohol, to protect yourself from a potential third-party lawsuit. For example, the customer began consuming alcohol at home. They have a flask in their pocket. They're mixing the drugs. They have a low tolerance, etc. But what are the potential legal consequences of overserving? Well, you have licensing consequences. You lose your livelihood. Your employer loses his license also. You have civil consequences. You lose your home, your life savings, and whatever else you've accumulated. The licensing consequences are relatively straightforward.
If you're caught, you can lose your license or could result in fines and restrictions on your license.
The civil consequences require a more in-depth treatment. When looking at the civil consequences, there are a few specific questions to ask. What can I be sued for? Who can sue me? What types of damages will I have to pay? What can I be sued for? Since 1933, when the 21st Amendment ended prohibition, Oregon laws have attempted to control the liability for those injured by intoxicated persons. These laws are commonly referred to as third-party alcohol lawsuits. Anyone licensed or holding a permit issued by the Oregon Liquor Control Commission may be held liable for serving or providing alcohol to a patron or a guest who is visibly intoxicated. Oregon law spells it out simply as this: it is illegal to serve someone to the point of visible intoxication, and it is illegal to allow a VIP, a visibly intoxicated person, to consume alcohol. Important things to remember. You can overserve someone even if you have no evidence that they've had anything to drink beforehand. The only question is whether they appear intoxicated. Number 2, courts have pointed out that the intoxication need not be obvious. Any person who seems intoxicated may not be served. That's a little dicey. Basically this: the light switchers, the ones who come in, they seem fine. You serve them one drink and suddenly they're intoxicated. Obviously, they've been someplace else before. Problem is, you have now overserved them. And then on the flip side, you have the old seasoned pro, the one who can sit there and put down one drink after another. By counting drinks, if you serve this person an enormous amount of alcohol and they're not showing any signs of intoxication, but you know that they got to be buzzed by now, that can come back and bite you. Now, what if the person you overserved does something other than drink and drive? We've been talking a lot about drinking and driving, but actually slips and falls are a much, much bigger issue. It is the person who gets drunk and takes a tumble down the stairs, injures themselves, and sues you because you overserved them. Consider the Oregon case where a man was overserved, fell down the stairs, and brought a lawsuit against the bar where he was drinking. The claim was that the server and bartender knew that he was drunk, and the only way in or out of the lounge area was via stairs. They also did not attempt to assist him while he went down the stairs. If you serve someone who is visibly intoxicated and that a person assaults someone else, you may be liable to the person who is assaulted if you had a reason to believe the person might act violently. In a 1997 Washington State court case, a restaurant patron grabbed another patron's head and repeatedly bashed it into the pavement in the parking lot. The man suffered serious brain damage, memory loss, and chronic headaches. The restaurant was held liable for those damages, which were in the millions. Now, what if you serve a minor? Serving any liquor to a minor can lead to a civil liability lawsuit for any foreseeable act that the minor does. You can be held liable to the minor if the minor hurts himself or herself. But you can protect yourself from some liability by checking the buyer's identification and asking the buyer to sign a proper certification card, which in Oregon it is called the OLCC Statement of Age Card.
Alternative backup ID.
Even if you check the identification, however, you could be held liable if a jury finds, under the circumstances, such as the identification was obviously altered or fake, or suspicious behavior on the part of the buyer, you should have known the buyer was a minor. And if you have a private party, or if a private party is held at your home and you knowingly allow minors to consume or to be in possession of alcohol, you can be fined up to $5,000 and be placed in the jail for 1 year. Anything used for a party where alcohol was furnished to a minor, such as a stereo, your furniture, refrigerators, can all be seized by the police.